So I'm really excited to present today because I heard some conversation a few minutes ago about free expression, and that's not something that has come up in a while. So I'm kind of I'm stoked for that, because usually at these conferences people are kind of in or out on the First Amendment, and it's not the most interesting topic, right? But I think it's timely, so I'm excited. So basically, I think we're going to try to sync up 3 devices here so we can all see the same thing. So we have to do the obligatory introductions, right? I'm Brandon Huffman. I have a law firm in Raleigh, North Carolina called Odin Law and Media. I practice almost exclusively in games and games-adjacent industries. I do corporate and IP matters for the most part, and I'm also general counsel to IGDA, and I have to say at the beginning of every presentation that my views are not those of IGDA. So, Marc, do you want to introduce yourself?
I'm Marc Whipple, and if you've looked at the booklet, you'll see that somehow I have the longest bio in there, probably because I'm the oldest. But I won't read the whole thing. I have been the general counsel of a couple of different video game companies. I now have my own law firm at legalinspiration.com, where I help a lot of game people, a lot of other things. I am also a patent attorney, and as you just heard, gaming patents have had a rough few years, so I had to diversify a little bit. But that's where my expertise comes in, and as you will see, we're going to talk about gambling. I have been the GC of a company that made both unregulated video games and regulated video games, so I have kind of a unique perspective, if I do say so.
All right, so the First Amendment, what is it? So I've got the text of it there. We're not going to talk about all of the First Amendment because most of it doesn't matter to game developers, at least in their capacity as game developers. So we're going to break it out. So you see Congress shall make no law respecting, and then there's a bunch of things that Congress isn't allowed to regulate, right? This is really all we're talking about today. So we're going to go ahead and censor the First Amendment and say Congress shall make no law abridging the First Amendment or abridging the freedom of speech. And what does that mean? So protected speech, there's a lot of justifications for protecting speech. You hear these in more philosophy classes than in law classes, but the justifications are usually things like the marketplace of ideas, right? You want everybody to contribute their ideas. The strongest ideas can win out. You want citizen participation in government. In order to do that, you have to protect their ability to participate. There's the sort of fundamental idea, the more European or Canadian idea, that it's an individual liberty issue, that you should be allowed to say what you want to say. And then you have the artistic, angle, right? Expression, furthering the arts and sciences. The Copyright Act, right, is always a goal of the Constitution, whether or not it explicitly says art. But expression, including commercial speech, is protected speech. Now, commercial speech is treated a little bit differently. It's not quite as protected, but it is protected. So what does the First Amendment not protect? It doesn't protect fraud. So, for example, you can't say this game will have 32 playable characters if you pay $300 on Kickstarter, and then it really doesn't have 32 playable characters. That's fraud. You can say this game will be great, even if the game actually isn't great, right? That's your opinion. You're allowed to say something will be great. It doesn't protect defamation. You can't say Brandon steals money from elderly people, because I don't. That's not true. That's defamation. And I could sue you for that. Oh, what's going on here? Okay. Yeah. You can't use what are called fighting words. Yeah.
Brandon's the name of a character in your game.
Well, I guess I meant you can't specifically identify me and say that I steal money from elderly people. You can't use fighting words. So this is a really particular one that gets misapplied by a lot of people. But basically, you can't say something like, why don't you pick on somebody your own size pig to a police officer? That's fighting words. If you said, why don't you pick on somebody your own size to me, that is probably not fighting words, believe it or not. But what you can say is, I don't like you. You can call me names. Insults are protected First Amendment speech. Clear and present danger, sort of along the same lines as fighting words, often gets misapplied. But basically, you can't go around saying like, hey guys, we should all get together and support Al-Qaeda, right? Like, you can't do that. That's not protected speech. You can't make a true threat. You can't threaten to murder someone. You can't say, I'm going to kill the president if he does X, Y, Z. That's not protected speech. But you can say, I don't like you, or hurl insults at the president. Obscenity is not protected. The classic example of obscenity is child pornography. It's pretty easy to identify when it's children that it's not protected speech. The borderlines of that have been tested a lot, actually, believe it or not, because criminal defendants with a lot of money will push the envelope as far as they can. It's one of the more discussed areas of First Amendment case law. What is protected is regular pornography without children in it, vulgarity, and offensive speech. So just saying offensive words is not unprotected. Also not protected, infringement of another person's rights. If you are copyright, trademark, privacy, or trade secret infringing, the courts are allowed to issue an injunction to stop that, even though that's a government action. Most important for video games and for our discussion today is that what is not protected is non-speech conduct. So this is where we get into the discussion of when does an action, a physical act, cross the line into speech, right? So driving a car is not generally speech. So the government can regulate that all day long, up and down, 2 ways from Sunday, right? Taking a knee at a football game, kind of speech in today's society, right? Even though all you're doing is kneeling, it has a meaning behind it. So it also doesn't protect anything that comes from a private actor. So Congress shall make no law. So that doesn't say Facebook can make no policy, right? That doesn't say Valve is not allowed to ban a game. That says Congress shall make no law. So private actors can do what they want inside of their walled gardens. It also says freedom of speech. So again, doesn't protect the non-speech things we just protect.
I'm just going to pipe in with one quick thing. Everything he said is right, but always remember that if somehow federal money is involved in what a private actor is doing, the First Amendment may attach. The classic example is universities. Even private universities, if they take federal scholarship or research money, the First Amendment may apply to them because they may be acting on behalf of a government interest. So, like if Facebook were to somehow get a contract to do the citizen participation meetings for, Pierre, North Dakota or whatever, it might suddenly start applying to that activity of Facebook's. But other than that, he is absolutely correct. Yet another reason never to take government money if you don't have to.
Also, so what does protect mean? So this is where we get into the weeds of First Amendment law, right? And you can do a whole semester on this. We're going to do it in about 5 minutes. But so what does protect mean? It protects from regulation. So regulation means that the government imposed regulation. Government is making a law regulating speech or speech conduct or expression in some way. And it also applies to court-ordered restraints. But protected speech can still be regulated. It just has to go through a bigger constitutional hurdle to do it. So a higher level of scrutiny applies to protected speech. If the regulation is content-based, the higher level of scrutiny is what's called strict scrutiny, which means that the law has to be narrowly tailored, which means the law can't be too broad, it can't be too narrow, it can't be unnecessarily burdensome. So an example of a law that's too broad is we want to stop people from, doing dangerous things on a parade route. So we're going to ban parades. That's too broad. Too narrow might be we want to stop people from hurting the roads when we have parades, and by having trucks that are too large, they hurt roads. So we're going to ban 18-wheelers with a weight over 4,000 pounds in parades. But I didn't ban, maybe a 12-wheel truck over 4,000 pounds. It's probably doing the same amount of damage to the road. It doesn't sound like a speech law, right? But it could be, and it's too narrow because it doesn't accomplish the purpose. So content neutral, this would be your time, place, and manner restrictions. So instead of saying, we're going to prohibit what you can place in this parade, or what you can say in this parade, we're going to say the way that you put it in the parade, right? And the truck example is probably more of a content neutral one, believe it, actually. So maybe not the best example for the strict scrutiny, but so content neutral is time, place, manner restrictions, things like you can put newspaper boxes on the sidewalk, but you can't put them within 10 feet of an intersection, right? It's just about where you can do the speech. It's not about what you can say. So when you have those kinds of laws, those are intermediate scrutiny, which are important to a substantial government interest. It doesn't have to be narrowly tailored. It has to be important. It doesn't have to be a compelling interest. It just has to be an important interest. It has to be unrelated to the suppression of free speech. So the law can't be specifically designed to suppress free speech. You can't say no protests within 500 feet or within 500 miles of Capitol Hill or something like that, right? It has to be narrowly tailored in a different way than strict scrutiny. Narrowly tailored here means no greater restriction than necessary. It doesn't mean it can't be overbroad, or it can't be under inclusive. It can't be. It just has to be no greater than necessary. So if you're prohibiting speech that you could craft a law that speech wouldn't be prohibited and it would still accomplish the important interest, your law is going to fail even intermediate scrutiny. And it has to leave open ample opportunities for communication. So the government couldn't ban Facebook to solve a problem with, Russian trolling, for example. So the First Amendment and video games specifically, so this is really the one case that we have on this at the Supreme Court level, which is Brown v. Entertainment Merchants Association. This was a Supreme Court case that is the only Supreme Court case that I'm aware of to ever mention Mortal Kombat. So basically, California passed a law that said that there were restrictions and labeling requirements on who could sell or who could buy violent video games. Minors were not allowed to buy violent video games, and they had to be labeled in a certain way. So the EMA protested and filed a lawsuit, went all the way to the Supreme Court. The Supreme Court decided that case in 2011. It was the first Supreme Court case to say that video games are actually free speech, that they do contain expression worthy of First Amendment protection. But of course, even free speech can be regulated, right? So then, violent video games are not obscenity. This is another takeaway from Brown v. EMA, that Mortal Kombat, despite being violent, does not constitute obscenity. It doesn't rise to the level of child pornography, right? California did not have a compelling interest in the specific regulation. They made some arguments that it would prevent psychological or neurological harm to kids, but they relied on a bunch of garbage studies to make that argument. The Supreme Court basically said your science is bunk. Their evidence was really, really bad, and it was basically science that was designed to produce the result they wanted. They also said that even if the state had a compelling interest, the law was not narrowly tailored enough to meet that objective. So this was because it's protected speech and it was content-based regulation. It has to go through this strict scrutiny analysis. So it was over-inclusive, meaning that not all children were forbidden from buying the content, right? If you were with a parent, your parent could allow you to buy it. So we're not solving the neurological harm if we're allowing parents to buy it for their kids, right? The neurological harm, if we buy into the idea that the neurological harm exists and we allow parents to give it to their kids, we're still allowing the harm. So it was under-inclusive in that way, and it was over-inclusive because it abridged the rights of parents to decide what their kids could buy, because if you sent your kid to the store without you, they couldn't buy what they wanted, right? So it's kind of odd how that over-inclusive, under-inclusivity works out, right? You're banning too much speech because you're stopping this from happening, but you're not banning enough speech to accomplish your goal at the same time. So it's really hard to fit in that narrow window that's allowed when you're regulating the content of speech. So the importance of this case is really embodied in this Scalia quote. I won't read you the whole thing, but basically he goes through like the history of everything that people have ever had a problem with in free speech. So he talks about dime store novels, and he talks about, then it was films. Everybody hated film. Films were corrupting the youth. And then he gets around to video games and says, well, now it's video games, right? It's today's scapegoat. And the significance now is that the court is different. We don't have the same 9 justices. And this is important because the decision was a plurality decision. It was a majority decision of 5 in the judgment, and then it was a concurrence of 2 and a dissent of 2. The 2 concurring justices basically said that they, in this case, felt that the law was too broad and also too narrow, but they could see a different law that would be totally fine. That it was just the way California did it in this case that was a problem, that others would be able to pass that threshold. The 2 justices that have left the court, one through retirement and one through death, have been replaced by justices that we don't know where they're going to land on this particular issue, right? So if you lump the concurrence and the dissent together, and you can see now we're at kind of a different breakdown, right? So if one of those two flips sides and they look at a different law a slightly different way, suddenly video games might not be regulated as speech quite the same way. And this court has not shown a whole lot of, deference to precedent in the way that a lot of other courts have. The Roberts Court prior to Gorsuch certainly showed more, but the Roberts Court now has shown a tendency to shift away from precedent. And then we'll go to gambling.
First of all, I would say that everything he just said is super accurate, but here's a note you can make, and all the law students and lawyers in the room will probably remember this. There are 3 different tests for First Amendment allegedly infringing laws. One is strict scrutiny, which means the person trying to speak wins. Intermediate scrutiny, which means who knows who will win, and the rational basis test, which means the government will win. So if you've ever wondered what those 3 things mean, that's the usual translation. Anyway, back to gambling. As you can see, gambling is very complex. There are any number of websites that you can go to. There's a good one called U.S. Gambling Regulations. Every state in the union has its own gambling rules. No 2 of them are the same. The variance is enormous, probably one of the larger variances in our federal system. But most of them descend from the common law definition of gambling, which is what I have here on the screen. For something to be gambling under the common law, it has to have 3 elements. It has to have chance. Chance does not mean randomness. Chance means a factor you can't control. For example, betting on a football game. The outcome of a football game is not random. The better team will win, usually. But you have, unless you're playing on the game, and this is why we don't let athletes bet on their own games, unless you're playing in it, you have no control over the outcome. So to you, it might as well be random. So if you wager on the outcome, that is an element of chance, because it is outside of your control. Consideration. That's your wager. That's what you're staking. Risking value. It has to be something of value. It doesn't have to be money. Back in the common law days, it could be a fine set of draft horses or whatever. But it had to be something with value. And what something of value is something that we might talk about a little bit more if we have time. In this particular context, it becomes very complicated. And then there has to be a chance to win a prize. There has to be a chance of your consideration being converted into a prize, which again is just something of value. It doesn't have to be money. That's a very common mistake that I hear with people who think that they have invented a new way to implement legal gambling in their killer app. People have been trying to get away from gambling regulations, if not from moral anti-gambling, from getting away from taxation for literally thousands of years. You have invented nothing. Trust me, somebody has already come up with it. Just look into the history of pinball machines if you don't believe me. That's why pinball machines have flippers, is so that now you can say it's under your control. They didn't used to have flippers. Not all states require all 3, and every state is different. For example, there is one state where you are not allowed to show playing cards on a screen if there's a chance to win a prize, even if the prize is not won by chance. There's just an absolute ban on showing playing cards on a screen. It's hideously complicated is what I'm trying to get at. But basically, if you've got all 3 of these things, or arguably all 3 of these things, or if people are giving you money and might get something valuable back, you need to talk to a gaming lawyer. Okay. So then we get into the point where I think Brandon and I may have a little bit of a polite disagreement, which is gambling speech at all? He just talked about the history of this. The history of this is the history of our country, and before that, it's the history of many countries, of what is protectable speech, what should and shouldn't we allow. But it has to be speech to be protected. It can be a speech-like act, taking a knee, interpretive dance, whatever. But in general, U.S. courts, in the U.S. in particular, but generally they say speech is communication. If there's no communication, it cannot be speech. So it could be expressive conduct, which is the taking a knee. But are you intending to communicate, or are you just tired? Did you just want to lay down? If this had never happened with the protest, that taking a knee was a sign of protest, if the NFL just said, we want you people standing up, looking straight and alive and engaging the fans, and one player said, you know what, I'm just gonna kneel because I'm tired. I don't want to stand up. This stuff is heavy. They would be perfectly within their rights to discipline, and no one would argue that that was speech. That was just him not doing what he was supposed to do. So the context and the intent are very much a factor. So my question about saying that a gambling game is speech is, what are you trying to communicate other than give me some money and you might get some back? Because that's not protected speech. That's not speech at all. To me, a gambling element of a game that itself might be protectable speech, absolutely, is a mere mechanic. It's not speech at all. So that's why I question this. And I've been around a lot of interesting variations on this. So I appreciate that my standpoint is not privileged, but I've looked at a lot of these. So that's where I come from. As I come down on the side of your game may be protectable art. The fact that you want to take people's money and give them something of value based on the outcome of chance is not protectable art. That's not speech at all. That's you trying to make money. But suppose I'm wrong. Consider the possibility that I'm wrong. If it is speech, is it protected? And we already talked about this. Brandon did a great job of talking about commercial speech is usually subject to intermediate scrutiny, sometimes even rational basis, depending on what it is. Pretty rare for commercial speech to be subject to strict scrutiny. If a company wants to make an artistic statement unrelated to commercial activity, that's protected again, that's strict scrutiny. But if it's just, here's our advertising, advertising is commercial speech, it's protected, but much less so. The number one thing that commercial speech requires to be protected by the First Amendment is it must concern lawful activity and it must not be misleading. Ordinary speech, you can say everybody should be a criminal. As long as you don't say you personally should stab the guy next to you. You're not allowed to do that. But you can say people should be allowed to do crimes. That is protected speech, believe it or not. But it's not protected commercial speech because it's not lawful to do crimes. So be whatever, do crimes, but not sell things and do crimes. Gambling is an illegal activity. So if you're talking about gambling, which would otherwise be illegal, then you're not protected. And I realize that's a circular question in some ways, and it also must not be misleading, and this is really important as far as I'm concerned. A lot of the loot box systems and other systems of getting things of potential value are so non-transparent. The way that I describe it is, I could pick several major titles and take their loot box system. If I took the pay table from their loot boxes, put it in a slot machine, and put it on the floor of a Las Vegas casino, I would go to prison. Because that's how dishonest they are compared to a slot machine in a casino. It's not even close. Some of them are perfectly transparent and perfectly good. Per se, I don't object to gambling or loot boxes. I only insist that if something is gambling, we treat it appropriately. So let's see. So then, and we already talked about the features of scrutiny. There's a famous case called Central Hudson Gas and Electric where they get into all this stuff. That's where the points from Brown are important. The Brown case cited Central Hudson, as do many First Amendment cases. So then we get into the current landscapes of statutes and cases. Brandon did all the work to find these statutes, so I'll let him do those.
So you'll see that some of these are dead. There was a state bill in California that is dead. There is a bill in Hawaii to put a minimum age on loot boxes to buy them. It would be 21 years old. Minnesota, similarly, there was going to be a minimum age of 18, and you had to disclose the odds of winning. Indiana, there's a bill that specifically asked the Attorney General to look into loot boxes, loot crates. In Washington State, there is a bill, I believe that's actually passed now, if we have any Washington lawyers here who can let me know, but there is at least a proposal, maybe even law, that says the Gambling Commission of the state of Washington gets to look at each individual situation and decide if it is gambling or not. And then we have a federal bill that bans pay-to-win transactions, loot boxes, and microtransactions in games targeting children. And so that's where we're going to talk a little bit more in a minute, but I think this next slide is you.
Yeah.
So we'll talk a little bit more about the federal law in a minute and how the free speech angle plays there.
And by the way, hitting on that gambling commission, almost every state in the United States allows gambling of some sort that's regulated. Almost every other country in the world does, or at least a large majority of them do. They all have gambling commissions, and they have very arbitrary jurisdictional powers. For example, there was a big fuss in Illinois a few years ago about whether FanDuel and the other one, the fantasy sports sites that pay real money were gambling or not, or whether it was a game of skill. And the Illinois attorneys general issued, in Illinois, it was the attorney general who issued an opinion. In, I believe it was Oklahoma or Nebraska, it was the gambling commission that issued an opinion and said, we have jurisdiction over this because this is gambling. It is within the ambit of our powers. Most state gambling regulation statutes are extraordinarily broad. Due process protection is much more limited. A favorite saying of gambling regulators, a gambling license is a privilege, not a right. So if you want to conduct gambling in our state, you will do what we say. So you never know when a gambling commission could literally swoop down on you. And some of them, I think, even have capes, but usually it's a metaphorical swoop where they just get, you know what? You're operating a gambling outfit in our state. You're going to need a license or you're all going to jail.
And the interesting thing too, with some of those like sports betting cases, was that for a lot of the prosecution, a lot of the like federal government coming down on that stuff wasn't about gambling. It was about the Wire Act, and it was about fraud in money transactions.
Yep.
So this can come at you in a lot of different ways when it's non-speech, right?
Yes.
Yeah.
The main electronic one that's now is called the Unlawful Gambling in Internet. I can never remember the exact acronym, but it was designed to stop wire betting on sports fraud and online poker. But arguably, it applies to some loot box stuff if it's cashable, which we're going to get into in a second. And actually, we're going to get into it right now. So these are some cases that have actually been decided about this. Now, some of these were about loot boxes, and some of them were about more general online casino gaming. So please keep that in mind. And it's something that, I'm going to be posting some of this on my website, and you're welcome to talk to us at any time or drop us a line. But I'll just hit these cases really quick. These are the bright line. You should be looking at these to see how judges think about this stuff cases. One of them was, these were all in federal court, but federal courts apply state laws, which is yet another thing that the non-lawyers are like, what? But they do. Because there are no general federal anti-gambling laws. So it's a question of whether you do that. The reason they're in federal court is because the person being accused is usually a company that's in another state. So you have to go to federal court so that it's neutral ground, so to speak. All the lawyers are like, wow, that's oversimplifying. But that's a general gist of it. Scoto v. Sky Union, which is where if we had a deal with loot boxes, where loot boxes were ruled not gambling because they weren't exchangeable and the publisher didn't support easy ways for players to trade. That's where we get into prize and value. If I give you an achievement, or if you play Warcraft and you get a rare mount, I have a Violet Proto-Drake. I value it very much, but I can't give it to anybody. I can't sell it. I can't rent it. I can't do anything with it that might generate any kind of money. Arguably, it's not a thing of value in that meaning. But suppose that Warcraft is like, you know what? For $5, we'll let anybody transfer anybody's account to anybody else. Now you're like, I want that Violet Proto-Drake. Here's $5, Mark. Give me your account. Well, actually, I'm going to get hundreds and hundreds of dollars. You're going to give Blizzard the $5 transfer fee. Now it's easily transferable. That actually might make a huge difference in the ultimate outcome of deciding whether or not that Violet Proto-Drake is a thing of value, because now it's alienable. Now it's transferable. In this game, the TOS, and the next game had a very similar outcome. The TOS explicitly forbade trading accounts or otherwise transferring these things that you could get. And the court, again, very rapidly came down on, this is not a thing of value because it's not transferable. You can't do anything with it. You're not allowed to move it. Yes?
What if it's like a rare recipe and you make items and sell it to other players?
That's a great question. I don't think the court has ruled on it. I think you've just added one layer of obfuscation that eventually courts would see through, right? The sort of gambling regulation state by state, the way that it usually gets tried in the courts is not loot boxes, right? It's sweepstakes centers in the strip malls where old ladies go instead of staying at the nursing home, right? It's not just ladies. I shouldn't have said that. But old people, it's always old people. I don't mind saying that. go to the strip malls and they pump money into these, not casinos, right? And so the gambling laws are constantly adapting, and the casinos, not casinos, are constantly changing what they're doing to be one step ahead of the regulators, including things like adding a layer of obfuscation where, you're playing this game that's not a game of chance. You're playing this game of skill, but that game of skill determines how many chances you get or something like that. So adding that layer of, your skill is making the recipe maybe, right? Or finding all the items you need to make it or whatever that is a layer of obfuscation that would certainly delay enforcement of anything, but I don't think ultimately would stop it if it was decided that it was, otherwise an enforceable situation.
And the thing to remember on that context is a lot of times when you're the case of first impression, the regulator, whether it be a law enforcement agency or a gaming regulator, will basically just come to you and say, knock it off and we'll say no more about it. That's a dangerous path to tread, because if you decide that you don't want to do that, or they decide that that's not their opening gambit, that their opening gambit is a warrant and a subpoena and trying to put you in jail, you have no control over that. That's completely what we call prosecutorial discretion. And again, this is not legal advice. Neither of us are giving you legal advice. For God's sake, don't listen to either of us. At least not here. But when you don't know what that phone call is going to be, that phone call could be, you know what? Do you have a criminal defense attorney? Because I need to talk to him. Or it could, or her, them, sorry. Or it could be, we have a problem with this that we'd like to come and talk to you about. And they come and talk to you about it. And we're just not comfortable with this being within the regulations. We need to discontinue it within 30 days. Which, by the way, is what happened to some of the FanDuel fantasy sports people. They would get an adverse reaction in a given state, and they would just pull out of that state, but not keep going. They would keep going in other states. So that is something to remember, but that the other side of that is they do have that enormous discretion. You don't know which call you're going to get. Or if you'll get a call at all. They might be busy that day. Who knows? Yes?
So you mentioned they'll go in one state, they'll pull out in another state. If you were to receive a notice and then you stop your action within 30 days from the state, but you continue to operate elsewhere, is it common practice for other state agencies to then view you with a more critical eye than if you actually object, or is it just as likely or potentially more likely that by objecting you will draw attention in other states?
The definitive answer to that question is it depends. You might get something where all these regulators, by the way, talk to each other. They go to conferences like this only for gaming stuff. They communicate constantly. If you get in trouble in one state, the other state might find out about it. But remember, the flip side of it is those two states have different rules. It might very well make them think, oh, this person is, a compliant person. This entity is willing to work with regulators. It might give you a positive light. On the other hand, they might say, you know what? My friend Mike over in Oklahoma already looked into you guys and you're shady as hell. And, get out of here. I don't even want to hear your side. I already talked to Mike in Oklahoma. So it depends. It really does. Being compliant and polite and professional will almost never hurt you. This is the thing. And another, by the way, gotcha sort of thing to remember, almost all of these regulatory agents for state regulatory agencies are former law enforcement officers. So they have a law enforcement officer mentality, which can be good, can be bad, not insulting them, just saying that's the way they think. Plus, now they work for an agency where they don't have to prove you're wrong, you have to prove you're right. That's literally how gaming regulation works. You go to try to get a game approved from an actual lab. They don't have to prove it's not compliant. You have to prove that it is. And if you can't prove it, you can't put the game on the floor. That's how they like to think. And then real quick, we'll just hit these other two. Now, these latter two, Phillips and Cater, were both online casinos, not loot boxes as such. But it was still virtual chips that you win in a casino. Is this a thing of value? Is this a prize within the meaning of the law? And the first one, they found out that even though you could buy more chips, you can't cash them out, you can't transfer them. They're not a thing of value. Value implies some kind of alienation or exploitation ability. There was none. It was playing slot machines, only you won money that you couldn't actually spend, which is, nice work if you can get it, as far as the app developer was concerned. But The last one, Churchill Downs, and yes, it is the race company, the racetrack. They have a multinational gambling company as well as just the racetrack. They had a system where technically you couldn't cash the chips. The app wouldn't let you turn chips back into money, but it was very easy to trade them back and forth with other players. And there was a pattern of activity that the manufacturer of the app was allegedly encouraging, where players were trading chips back and forth and using that to, it's like kind of PayPaling yourself money back and forth, or to use a more modern version, Bitcoining money back and forth and saying, well, Bitcoins aren't money, so I'm not subject to wire transfer laws or whatever. Yes, you are, eventually. So that was where they went with Churchill Downs. It was just too close to, technically you're saying that they can't cash out, but your TOS don't prohibit it. You actually provide a mechanism for encouraging people to do it, and people are at it. That's gambling. You have to stop.
So now we'll get into the proposed federal law, and there's going to be a lot of little tiny text up there. You don't need to try to read it. It's going to overlap itself pretty soon anyway. So the federal law that's proposed has been referred to as the Loopbox Bill, and it's been referred to that way mostly by games media. It is much broader than just loot boxes. So just to run through some of the definitions that I think, so even if we accept Marc's view, or we accept a view, not necessarily Marc's view, we accept a view that loot boxes are gambling and that gambling is non-speech. I am still of the opinion that this bill is void under the First Amendment if passed. So let me run through why. So we'll talk about some of the definitions. So the first definition, prohibition here is, it is unlawful for a game publisher to publish an interactive digital entertainment product that is not a minor-oriented game if such product contains pay-to-win microtransactions or loot boxes, and the publisher has constructive knowledge that any of its users are under the age of 18. So basically, you cannot sell this product. Not you can't sell the loot boxes. Not you can't sell the loot boxes to children, which the stated goal of the bill is to prevent children from becoming addicted to gambling, right? You cannot sell this product. If it contains these things, whether or not those things are gated, doesn't matter. If you have any constructive knowledge that it might be used by someone under 18. So there's a lot of little steps there we have to jump through, right? So I think I'm changing the slide there. Okay. So the next definition, it also applies to digital game distributors, not just publishers. It's not just the people who make and ship the game. It's the people who then sell it. And the definition here includes anybody. It would include Valve. It would include Epic. It would include Toys R Us. Well, not anymore. It would have included Toys R Us when Toys R Us existed. So then we get into, well, what's a minor-oriented game, right? Because we've got a double negative that it's unlawful to do something in any game that's not a minor-oriented game, which means it's unlawful in a minor-oriented game. So a minor-oriented game is demonstrated by, and this is where we get into the content-based restriction on speech, right? The subject matter of the product, the visual content of the product, the music or audio content, the use of animated characters, the age of the characters or models in the game, the presence of the product, or the presence in the product of celebrities who appeal to individuals under the age of 18. I don't know how many of you have played a video game with a character that's not animated. I don't think that's how video games work, right? They're all animated. Celebrities, so I guess every sports game theoretically now is a minor-oriented game, no matter what those people are doing, if they use the real the sports players for the real players. The music or audio content, what music are you putting in a game that is not going to appeal to children, right? Or to someone under 18? Like if it appeals to a 35-year-old, it probably appeals equally to a 17-year-old, unless you're deliberately choosing stuff Marc likes.
It's fair. It's fair.
So then we get into the pay-to-win microtransactions. So there's a lot of text up there now. I'm not going to read all of it, but what I am going to say is that under the way this bill defines a pay-to-win microtransaction, it tries to carve out purely cosmetic stuff, but then it goes back and says it's pay-to-win if you can buy something that you otherwise could have achieved in the game. So cosmetic stuff is only not pay to win if you literally can't achieve it in any other way under this bill, right? A pay to win microtransaction is I can buy anything in the game that otherwise someone else has to earn, or I can buy additional game time, or I can accelerate the time in which I can take a turn. Basically, any microtransaction can be defined as a pay to win microtransaction unless it's deliberately designed to be purely cosmetic and not otherwise achievable. And then we have the exclusions, and where a lot of free speech things fall down is in the exclusions, right? You can, if you have a noise ordinance that says nothing over 100 decibels, but then you accept out church bells, now you've got a First Amendment problem, right? Because you've picked one type of speech over another. So we've got the exclusions here. So the exclusions are difficulty modes. If you scale based on difficulty, that is okay. If you can buy into the next difficulty level, that is okay. Cosmetic alterations, which I mentioned, but only if they're not otherwise achievable. And then we have additional game content. And I include this definition here because this would be basically any DLC falls under a pay-to-win microtransaction under the definition here. I think it's hard to argue that banning outright an entire sale of DLC because there's a microtransaction somewhere else in the game is not content-based. Anything that assists the user in receiving an award associated with a product that is otherwise available in association with the product without the purchase. And that's where that's that exemption where even if it's a cosmetic thing, if you can otherwise achieve it, so if you can get it through a loot drop in the game naturally, or you can get it by killing a particular enemy or whatever, and you can also buy it, it's now pay to win. And then the term loot box, and this one's particularly troublesome because I think that it shows that the senators who proposed it, really did not go through the nuance of what a loot box can be. A loot box, there was a loot box. We'll talk more about it soon. The loot box hearing at the FTC, but there was some math done by the executive director of the IGDA with some game developers who basically concluded that through combinations of chance and different variations on math and the way that the things can be implemented, there are about something like, what did she say, like 5.5 billion different combinations that could be considered loot boxes under this definition. So it's anything that in a randomized or partially randomized fashion unlocks a feature of the product, adds to or enhances the value of the product, or allows the user to make one or more additional transactions. So,
believe it or not, by the way, that has to do with pinball switches.
I do believe it, yeah, because it doesn't have to do with loot boxes, so it must have come from somewhere, right? So if something is somewhat randomized and you can unlock a particular feature of the product using something that's somewhat randomized, now it's a loot box under this definition. So who here has played any MOBA ever, right? Every MOBA has map features that are a little bit random. Those, well, not the map itself, the features in the map, a chest or something that in the game naturally occurs and you don't know exactly what's going to be in it. That's a loot box. That gameplay mechanic is gone now, right? It has to come out because it's a loot box. If you're going to sell this game that has any animated characters in it. And then we get outside the US. Do you want to talk about this or you want me to?
No, I'll start. And by the way, I don't necessarily agree that Congress can't do most of what's in that bill, but I agree completely with Brandon that it is hideously overbroad and will not survive challenge in its current state. So that's where we have differences and/or similarities. You can see that this is all over the country, all over the world. I mean, anybody here who is a developer or represents developers know that you can pick and choose to an extent where your apps go in the App Store, but you want them as broad as you can get them. And you're like, oh, great, this game is not gambling under the test, the Churchill Downs test. But then you try to put it in Romania, which is not on here, but it's just one of the other. I mean, obviously there was no room for all of them, but there are a lot of countries that have just come down on completely opposite ends of the scale. Ireland just had a case that everybody was really happy about because they decided that loot boxes aren't gambling. But then they kind of stuck in a little backdoor that thing said, but by the way, they're consumer purchases, which means consumer protection laws apply, which means now that the Irish equivalent of the FTC, which is the entity here that's also looking into it, can kind of control them based on transparency, for instance. They could say this is not transparent enough, therefore it violates consumer protection laws. You're like, well, it's not gambling, and they're like, you're absolutely right. It is not gambling. You're not going to jail. You're not going to jail for gambling. You're going to jail for consumer fraud. Jail is jail, as far as I'm concerned. South Korea, that's a great example. The industry is highly self-regulated. Gaming is huge in South Korea, as most people here probably know. But they disclose the drop rates, and to me, that's 80% of the fight right there. Well, okay, it depends on how you count, but first and foremost, protect minors. After that, fair and transparent. That's what we require of casinos. That's what we should require of anybody who's offering games of chance of whatever kind. So they disclose the drop rates right up front, and the regulatory agencies are like, okay, we're going to let that go. Belgium and the Netherlands, though, went the other end, and I've read some of these descriptions of these decisions, and they just literally said, of course this is gambling. You put money in, you might get something good, you might not. That's gambling. Knock it off. Or get a gambling license, one or the other, and comply with our regulations. In China, drop rates have to be disclosed. Fair enough. Japan, as you can see, prevents extras and misleading representations, and that is a whole more than 1 hour probably seminar all by itself, what we've identified as the Kampu Gacha crisis, where literally Kampu Gacha is a little bit different from loot boxes, I hasten to add. But literally overnight, the Japanese consumer protection regulator decided that Kampu Gacha in phone games, which were huge in Japan at the time, was gambling and that it should be illegal. And there were companies that lost 20 to 30% of their market cap in a day, because that was how big a percentage of their revenue was. Now, I don't know how much loot box revenue contributes to EA's bottom line, but it's probably not nothing. And if all of a sudden the FTC says, you know what, loot boxes, no, not having that, that's going to hit them hard. It's going to hit their stock value. It's going to hit their management. It's something that I don't think that people are necessarily paying enough attention to. And the only reason that Japan isn't more highly regulated is that they immediately implemented draconian self-regulation. And then every so often since then, they start slipping and people start pushing the boundaries, and the Japanese consumer regulator kind of says, hey, what are you doing over there? And then the whole industry is like, knock it off, stop. And they pull back. Sorry, I'm very dramatic. But that happens there on kind of a cyclical basis, and I can see us falling into that pattern, only Japan's consumer regulator is a lot more friendly in some senses in that they weren't preparing to send people to jail. Like I said, even the regulators in the US, 9 times in 10 are like, we have a problem, let's talk. The 10th time, they show up with a warrant and handcuffs. Japan doesn't do that. We will. I'm not sure that it's going to, but it's possible. So to me, this is something where you tread very, very lightly.
So most recently, the most recent development here, so the Senate bill is still sort of sitting in committee. We don't really know if it's going to move forward. The Senate right now has some other things on its mind, I think. But the August 7th FTC hearing was interesting. If you didn't watch it, you can still go back and get the video and watch the portions of it. It was a full day, so you can watch portions of it that are interesting to you. But basically, there was a panel from every potentially interested party, or not every party, but every potentially interested industry group or consumer watchdog group, represented by obviously trade groups and that sort of thing. But so the concerns expressed by the regulators were gambling, which we've talked about, that it would be a gateway to gambling to have these loot boxes and microtransactions, that people are manipulating the odds for profit. That is, that the odds are not static, right? If you buy something once, you buy a loot box one time, and you have odds of 1 in 100 of winning an item. But then you buy a loot box the second time, and your odds are not still 1 in 100 of winning that item. That's a problem for regulators, right? Because they feel like the consumer is being manipulated. Manipulation of consumers and kids spending. So this is less about that odds changing and more about using the risk reward and the sort of free play period followed by a purchase to continue playing period that drives children to spend their parents' money. Virtual currencies. So this was a problem that was expressed by both actually gambling experts and the FTC, that use of virtual currencies is enough to segment the human brain into not realizing how much money it's spending. So you buy gems or you buy coins, and then you spend those gems or coins without really directly translating them into dollars. And that is especially true in places where what you're buying buys an in-game currency that the in-game currency is not even necessarily what you're exchanging for the quote-unquote gambling item, right? So you're buying gems, and you can exchange the gems for coins, and then you can use the coins for entries, and then you can use the entries to try to win a loot box. And so by the time you're actually doing the potentially gambling activity, you're 4 or 5 levels removed from actual money, and you don't really realize how much each entry is costing you anymore.
There's an old saying in the gambling business that the person who invented cards was smart, but the person who invented chips was a genius.
So then there was the truth in advertising concern. And so on the virtual currencies point, there is actually a First Amendment argument for virtual currencies, right? If you are playing a game, and in the game you are supposed to be in 5th century Egypt, it's going to take you out of that game if you go to buy something from a vendor in the store and you pay in US dollars in current value, right? So there is an actual artistic expressive argument for why virtual currencies could be important. I'm just not so sure that it carries through the loot box transaction particularly, but there is a good argument for why virtual currencies are First Amendment speech. The truth in advertising, this gets to Marc's point about commercial speech. The truth in advertising concern is absolutely outside of the expressive part of the game. This is just the advertising outside the game about the game itself. And so I've gotten a parentheses there because there was one regulator who asked the same question of 2 different people on 2 different panels at 2 different parts of the day. And so it was obvious that that particular regulator is interested in this question. And that question was, are streamers and YouTubers ever paid by developers and publishers to open loot boxes on stream? And the answer to that was a resounding yes. They absolutely do get paid to open loot boxes on their stream. That in and of itself, the FTC already has regulations around. You already have to disclose that you're being paid to play something, right? And those could be more broadly enforced, but they already exist. The follow-up question to that was, do those streamers ever get better odds than the consumers will if they play the same game? And the answer to that was also yes, that does happen. So if Ninja, not to throw Ninja under the bus, I don't know that Ninja does this. If a very high profile streamer, let's take any individual out of it, a very high profile streamer is paid by a particular game publisher to open a loot box, and they have a 1 in 5 chance of winning the best item in the loot box. And then they say, you can get this loot box too for $15 if you go to your game right now. And then I go to my game and I pay $15, but my odds are never going to be as good as theirs. And I've just watched them get 3 or 4 great items. That's deceptive advertising. And that's a very easy thing for the FTC to police. And so I think that's your initial, that'll be the first FTC enforcement in this space if my prediction is right.
And to add again that you have invented nothing. Casinos can show people in their ads winning. I'm sure you've seen ads. They can't show people in ads winning things that you can't win in the casino. Same principle. This is something gambling regulators and the FTC are very familiar with.
So the advocates for the industry made the arguments you've probably all heard, right? So loot boxes and microtransactions lower initial costs. It's actually a democratizing tool that allow people to buy games that they couldn't otherwise afford, right? So without loot boxes, the price point of a game would not be $60. Not necessarily loot boxes. Without in-game purchases, the industry argument is that the price point of a game would no longer be $60. That price point was set in the early 90s and has never gone up, even though the development budgets have gone up by about, 15,000 times?
Oh, yeah,
right?
roughly.
So despite global markets, despite having more opportunities to make money on sales, the costs of game development for AAA titles especially has gotten so high that it would cost more than $60. But by having these back-end transactions that are optional, you don't have to buy into them. Individual consumers are able to buy those games at the same price. So the argument is that it's actually better for consumers to have these. The second argument is self-regulation. We have an ESRB. The ESRB is looking into this. And the ESRB was there and announced at that hearing a program whereby Sony, Microsoft, and Nintendo have all agreed to require odds disclosure over the next, or have agreed to discuss, have agreed to agree in the future to require odds disclosure, and that secondary follow-up conversation will happen sometime in the next 12 months from that hearing, they said. And then there are the narrative reasons that I talked about with like the Egyptian drachma, right? So by 2021, so in the next 14 months or so from now. And that takes us to the end. So questions? I think we've got five, 6 minutes, something? 10. Uh-oh. Better ask some questions.
Come on, guys.
Doesn't have to be about the panel.
No, we know lots of stuff. Apparently, we were just that good.
Yeah, answered all the questions. You can also ask us, like, why are you so wrong? That's fine, too. Like,
Yeah, we enjoy it.
yeah. All right.
Right, well, we both have websites, and look, we're safe.
Oh,
Yes.
Yes.
Do you have any possible way to regulate or any sort of like solution to this problem?
So I've been on the self-regulation bandwagon for a long time. I think that this is again my personal viewpoint, not any of my clients, etc. I have been disappointed the ESRB didn't do something like they've done with Sony and Microsoft sooner, and Nintendo. I think that announcement should have been made years ago, frankly. The difficulty there is that the ESRB is an opt-in system, and there are a lot of games on the market that aren't necessarily even subject to, ESRB ratings, right? But I think that, the same way that the ESRB ratings sort of stemmed the tide of the violence in video games anger, would have been at least a good step towards letting regulators have something to say. Well, they've done something here. Let's see how this goes, right? But over the last few years, with the rise of a couple of very large titles and a couple of big outrage events, regulators feel like they have to pay attention, right?
I will say I'm not quite as, don't feel quite as good about that. I'll give you an example from regulated gambling. There is a jurisdiction in this country, which I will not name, where if the sheriff finds that you've got an illegal slot machine in your bar, what the sheriff will do is take the slot machine away and destroy it. He will not actually bring charges against you. He will just take your slot machine and destroy it. On average, one of these slot machines gets destroyed, let's say, every 6 months for a bar. Suppose the machine makes enough money to pay for itself in 3 months. What is the incentive of the bartender? To keep the machine and replace it every 6 months. It is a cost of doing business to have this machine literally hauled off by the police and destroyed. And what Brandon said about the ESRB is being opt-in. Apple and Google have the Play stores. Microsoft has the Microsoft stores. We can do a lot of self-regulation. We can do a lot of bottleneck regulation and requirement. Ultimately, if people are going to have these games that people are going to be able to gamble and win money on, and I'm being a little broader than just loot boxes, but in general, eventually they're going to have to be regulated because some people just can't be trusted with nice things. My hope is that they will be largely self-regulated and that it will kind of be a Japanese situation. We have the regulator who's keeping a sharp eye on it, and we'll let them know when they're crowding the limits, but we are probably going to have eventually some federal laws with some at least basic transparency requirements and protection for minors, if nothing else. The bill that Brandon recited, and I agree with him, is not the bill to do that with. But I think eventually that's going to happen. When, I have no idea.
Yeah, and so to the question of, is it permissible under the First Amendment? So if you accept that gambling is not speech in any situation, and I think Marc and I agree on that, like gambling itself is an act that is not expressive, and you agree that loot boxes or similar transactions are gambling, which I think is a less clear point depending on how they're implemented, then you get to the question of, is the regulation only focused at that particular thing, and what harm is it preventing, right? So if the harm is that we don't want kids to buy these, then the regulation should be kids can't buy these. The regulation should not be publishers can't sell this thing that happens to contain this item because kids might get it. That's not how the First Amendment works.
So with PAPSA and everything being overturned, and sorry, this isn't directly the topic of the panel, but as we see gambling on esports come more to the forefront, I mean, does that just look like sports betting as typical, or is there going to be a lot of unique issues there? And I'm totally happy to take my answer offline if this is a bigger conversation.
It is a bigger conversation in some ways, but in my opinion, I think that the regulators and law enforcement are going to be very comfortable eventually when they figure out that it isn't just kids playing Pac-Man, which we may need a few more regulators to retire before we get there. This is a big business and that these are athletes in most senses of the word. I think that they're going to be very comfortable applying, the analogy of what are professional athletes, in football, baseball, whatever, allowed to do, not to do. What interactions can team owners have and not have with people who facilitate gambling. That's my opinion.
Yeah, I completely agree. I actually think there's going to be an interesting moment, and I don't know which will happen first. It'll be a chicken or egg thing, right? Where either the regulators or the leagues decide that they have to start policing the players the same way that the NBA and NFL and MLB and everybody else that's in a traditional sports betting world do. I know that happens a little bit now, but I think it'll be a lot more aggressive in the future, either because regulators say they have to or because they do it to get ahead of the regulators.
Now, by the way, it is also my firm opinion that if, say, a team in the world Hearthstone competition or whatever, or any esport, is found to have thrown something because they placed massive bets against themselves, they could easily be prosecuted for fraud under existing legislation. I don't think that you can say, oh, well, they haven't passed rules particularly about esports. Eventually, you will get to the point where you have an ordinary garden variety fraud case.
So to bring this to a whole different point that we didn't bring up, I know that free speech issues have come up a lot in esports recently, and I think that right now esports is sort of not viewed in the same way that the other leagues are, but the NFL and the MLB and all of the top tier sports leagues have at some point gone through an antitrust hearing of some kind. And I don't know that Activision Blizzard is not inviting that scrutiny right now under, by creating free speech issues for its players. I think they're drawing scrutiny from regulators that otherwise would have ignored it.
Okay, that's time. Thank you very much for your kind attention.